In Redwood City, California, convicted wife and unborn baby killer Scott Peterson back in a courtroom trying to get a new trial. Inside the courtroom, juror number 7, Rochelle Neese, a.k.a. Strawberry Shortcake, on the hot seat. Did she commit juror misconduct? We have the latest from court and a look at the history of juror number 7.
Our Constitution entitles you to a jury of 12 impartial jurors, not 11.
In Pasco County, Florida, shock and outrage as accused murderer Curtis Reeves is set free by the jury in the popcorn movie murder trial. Tonight, we break down the case, the verdict, and try to figure out why Reeves was set free when others claiming self-defense, like Michael Draka, have been convicted.
We, the jury, find as follows: the defendant is not guilty.
In Taylor Mill, Kentucky, a young woman is shot and killed during an early morning home invasion. Now the suspected killer has been caught by police. Tonight, we examine the possible motive: imminent nuclear war and a doomsday bunker.
My daughter, 32 years old, brilliant lawyer, the sweetest thing that I ever had in my life. And she's dead because of this.
On the docket tonight in Columbus, Ohio, a doctor is accused of murdering his own patients with fentanyl. Why would he do it, and what is his defense?
He was given doses just 20 minutes earlier that would take down an elephant.
Plus, actor, singer, and entertainer Jussie Smollet looking for a new trial after being convicted for his hate crime hoax. He is facing up to 3 years in prison. Tonight's 13th juror question: how much time should Jussie Smollet do? Buckle your seatbelts. This hour of closing arguments starts right now. I'm Vinny Politan. Great to have you with us tonight here on Closing Arguments. Years ago, I was in Redwood City at the trial of Scott Peterson. He was accused of murdering his pregnant wife, Lacey, and their unborn son, who they had already named Connor. I saw the evidence, heard the arguments. I was convinced beyond any and all reasonable doubt that Scott Peterson was guilty, and the jurors in that case agreed and convicted Scott Peterson. He went to death row. He was considered the worst of the worst. Scott Peterson's been litigating ever since, got himself off of death row. He's now, I guess, in general population with the rest of the criminals in California. And now he's trying to get a new trial. And at the center of all of this, there he is. That's him actually in court Friday, trying to get a new trial. There he is. I'm looking at his hair, a little salt and pepper. He's getting older, getting close to the big 5-0. He's got his mask on because Scott wants to keep everyone safe around him, right? That's what he does. Keeps the people closest to him safe. Looks like he might have a little boot on his leg. I'm not sure what's going on there. Anyhow, he's in court. But this hearing is not really about Scott Peterson and what he did or didn't do, believe it or not. This hearing is about one of the jurors. And when we were covering this case back in 2004, there was one juror that just stuck out from the rest. Now, there were no cameras in the courtroom, and even if they were, we wouldn't put the cameras on the jury. But this juror, juror number 7, was the one that everyone was talking about throughout the trial, most notably because of her hair. She had this signature hair that you're seeing, and she got a nickname because no one knew their real names, or we wouldn't talk about their real names on the air. She was known as Strawberry Shortcake. Her name is Rochelle Neese, and now Scott Peterson is alleging that juror number 7, Rochelle Neese, engaged in juror misconduct so egregious that all these years later, 18 years later, Scott Peterson deserves a brand new trial, a second bite at the apple. 12 new jurors to decide and hear the evidence that I heard. The evidence isn't going to be different from the prosecution. It'll be the same evidence that convinced me and 12 jurors. Anyhow, let's bring in Court TV legal correspondent Chanley Painter to talk about what's happening out in California, because this is significant, this is important, this is real. I mean, there is a chance here that he could get a new trial. Let's begin, though, with juror number 7, Rochelle Neese. I just remember, Chanley, that we all were talking about her throughout the trial because of her look. She was young. What can you tell us about Rochelle Neese, juror number 7?
Well, she was about 34 years old when she was seated as a juror. She was an alternate juror, Vinny, one of the 6 selected after several weeks of jury selection, and she was not brought in to make a decision until this case went to deliberations. It was given to the jury. She replaced one of the deliberating jurors. Then she stepped in and became one of those 12 making that decision. And so, of course, like you said, she was known for her hair color, and she was very vocal after the conviction of Scott Peterson. She did many interviews. In fact, she was questioned today about an interview she did with Dr. Oz soon after about the alleged domestic abuse she suffered before becoming a juror. But also, she did in 2006 an exclusive interview with People magazine, Vinny, where she actually talked about letters that she wrote to Scott Peterson on death row in California. Extraordinarily, 17 letters, Vinny, that she wrote, very personal information exchanged between the two of them. And she told People magazine that her therapist advised her to do this. She said that again today on the stand, by the way, and that this was a part of her healing process to go through the trauma of what she had to sit through as a juror. But enlightening there, we expect to hear from that People magazine writer in this trial this week, Vinny, for the defense. And also she co-authored a book called We the Jury with 6 other jurors in 2007, where they talk about how the trial affected their life, and they had no regrets for sending him to death row.
Yeah, I remember when they were on their book tour, they came by Sirius XM. I was doing the Court TV morning radio show and spent about 2 hours with Rochelle and a couple of the other jurors who were making the rounds. They were in New York, sat down with them, and yet there was no doubt in their minds from the beginning. Okay, let's get to the hearing now. The defense called her, right? They called her as a witness, but she's kind of an adversarial witness, to say the least, to their plight. What was the defense asking her about? What was the defense going after her about?
Well, she was on the stand starting on Friday, Vinny. She just actually left the stand there in California. But yes, direct, because the defense, again, has the burden to show misconduct and bias on her part. So here's some of the major themes over the last couple of days of what she was questioned intensely on this direct examination, Vinny. They really focused on her questionnaire answers, that juror questionnaire where she said she's never been a victim of a crime, even though she had filed a restraining order against a boyfriend's ex-girlfriend. They also questioned her about her use of the nickname Little Man, which she called baby Connor, but she also called her own son. She has 4 sons, Little Man at the time. They questioned her about her financial status. And she had a financial hardship, but yet she said she could still serve as a juror. And then she wanted to also profit afterwards, according to the defense, with this book deal and all these interviews. They also questioned her about her extramarital affairs she had personally experienced and how that biased her against Scott Peterson. And then, of course, the letter she wrote to Peterson where she allegedly used the word little man and asked him why men cheat. Here's a little example, though, of how she was very consistent, though, in her response as to why she didn't include in her questionnaire her previous experiences with domestic abuse. And here's what she says to the attorney. She says, I'll say it again, I didn't write it in my questionnaire because it never crossed my mind, ever. It wasn't done intentionally, it didn't cross my mind. Well, on cross-examination of her today, again, a friendly cross-examination by the prosecution here, these are some of the things they brought up. That questionnaire, Vinny, it was 20 years ago, it was long, it didn't define any of the terms like defendant or plaintiff or what a crime was when she answered those questions, and that she actually was excused at one point as a juror, but Garrigo said, no, Your Honor, let's bring her back, ask her more questions about hardship, and then she was seated as one of those jurors. She also said that her therapist told her to write to Scott Peterson, and then again, this restraining order never crossed her mind. Here's how this exchange left for that cross, Vinny. I thought this was interesting for the prosecution. It says, you didn't think of yourself as a defendant? And she said, no, I wasn't, and I'm still not a victim. Had that incident crossed your mind, you would have disclosed it on that questionnaire. Yes. Did you ever have any bias of Scott when selected as a juror? Nope. Did you listen to all of the evidence of the case? Absolutely. Did you decide the case on just the evidence in the courtroom? Absolutely. And that's how the day ended. She was released, Vinny, but still on call in case she needed to be recalled.
Yeah, one point that you brought out there, I think, is extremely significant. She was excused but brought back by the defense because throughout this trial, when we were covering it, Everyone was wondering, ooh, I wonder if Strawberry Shortcake has a crush on Scott Peterson because he's so handsome. And that's why the defense wanted her. They wanted a young woman because they thought that she would just be enamored by Scott Peterson, God's gift to young women back around the turn of the century. Unbelievable. All right, Chanley, great reporting. Thank you so much for all those details. Those are important. Let's bring in our think tank tonight. Joining us in New York City, former senior homicide prosecutor Bernarda Villalona, in Atlanta, Georgia, criminal defense attorney Michael Bixon, and in Englewood Cliffs, New Jersey, criminal defense attorney, former prosecutor Al Wunsch III. Great to see everyone tonight. It's amazing. And Michael Bixon, you may have this problem with the women. You know, they're just Michael Bixon. The first time we booked him on the show, I almost said no because I'm not supposed to have guests who are better looking than the host on the show. That's just a rule, Michael, that I have. But I made an exception for you. I made an exception for you, and I'm comfortable having you on the show. Okay.
Thank you,
Bernarda. Is there anything here, anything as a reason to give this guy a brand new trial 18 years later because of what Rochelle Neese did or did not do on that questionnaire?
So as of now, from what I heard from Rochelle Neese, her answers are still consistent. There was nothing intentional in her answers or of not stating that she was a victim. She gave an explanation. She didn't consider herself as a victim or as a defendant. And also, more importantly, she said that she based her verdict on the evidence and nothing else. The question is going to be when they bring those other jurors in and to be questioned by the prosecutor and the defense attorney to determine whether there was anything that was said by her about her past that affected the deliberation. So we're going to have to wait and see to hear what else was said in that jury deliberation room that may have affected the trial. But as of now, I don't see any grounds for reversing his conviction.
Michael Bixon, let me play for you Janie Peterson, Scott Peterson's sister-in-law, who's been a strong advocate for him. And I understand family members will do that. Someone needs to be that person when you feel there's been a wrongful conviction. Here she is talking about this issue to Ted Rollins earlier today.
Well, every single juror in a criminal case makes a difference because you need a unanimous verdict, especially in a capital case. So absolutely she was a force. Every one of those 12 jurors was a force and needed to be truthful on their questionnaire and needed to be impartial.
All right, Michael, that's the stance of the defense and the Peterson family. They feel that she was not fair, she was not impartial, she was out to get him because of whatever bias that she brought into that jury room.
Yeah, well, I absolutely agree with their contention that it just takes one, and it absolutely does. One person could have made the difference in this trial. Regardless of whatever the evidence was, could one person have changed the outcome? Yes, and I think the fact that she had a domestic violence case where she was pregnant 3 years before this is extremely relevant. I think it's reversible error. It's hard for me to believe what she says on the stand at this point when you have a case 3 years prior where she's pregnant and getting beaten and doesn't admit it in the stand during her voir dire. And I think it's extremely relevant. I think it's extremely important. And I think it should have been brought up at the time.
Al Wunsch, your thoughts. How big of a deal is this? Could this, in fact, overturn a conviction from 18 years ago and force prosecutors to try the case again?
Well, I'm still feeling victimized from the ugly comment that I got from you earlier.
No, it was. I just said nothing, Al. I said nothing about you.
Bridesmaid, never the bride,
Al,
right?
We search for the truth on this show. I mean, come on, Michael Bixon. Just look at the guy.
I'm looking at him, okay, but you know, Vin, you and I have been together for a long time, my friend, and I feel that the bloom is off the rose, and I'm a little upset about that. But
okay,
notwithstanding,
put that aside. Put that aside. Let's get to this case. This is
the jury. The situation with regards to the jury questionnaire. That is so important to these cases, and it's so imperative that a juror tells the truth. And if they lie and they lie something significant, that is error.
Is this significant? Is this significant? She claims that she doesn't consider herself a victim of a crime in that scenario.
Except though that doesn't really make a lot of sense. I mean, I know domestic violence is not necessarily a crime. It's a civil statute in most jurisdictions. In New Jersey, it's civil. Okay, so it's not considered criminal. So it's not a, it's preponderance of the evidence and things along those sides. But you have a woman here who really has done everything humanly possible to get on that jury. And she looks like she had a motive to get there and a motive to make things work for her. And then she profited from it. So like there is a lot of problems that I see with regards to this case with her doing what she did. And, from a standpoint of, like the only thing I can do is trust that the juror is going to tell the truth. And if the juror lies like this, and we're seeing this more and more now, and it's very troublesome to anyone defending the case. And I'm not saying he's not guilty. And I'm not saying that if they try this case again, he will not be found guilty. It'll be just a travesty that would have to go forward and go to that poor family to, have to see this go through this whole, rigmarole again. But everyone is entitled to a fair trial. And if a juror is going to lie and say, oh, it was no big deal, it was enough of a big deal to go and make the report in the first place. And how you don't remember something from 3 years ago, that just doesn't make any sense to me.
Bernarda, I'll give you the final word here tonight on this.
Look, the judge has to find that it was an actual lie. As of now, we don't have any evidence that it was a lie. She gave her explanation. So if it comes off credible to the judge, a judge doesn't want to disturb a verdict. So I think the verdict is going to stand. The defense can't have buyer's remorse. He released her and then reinstated her. So now he has buyer's remorse beyond how it turned out.
We shall see. All right, they're with us the whole hour. Bernarda Villalona, Michael Bixon, and Al Wunsch, all here for the next hour. When we come back, what a reaction, an absolute explosion on social media. We were here on this show bringing you the verdict in the popcorn movie murder trial. Curtis Reeves set free, and you reacted. Tonight, what we're going to do is take a closer look at that verdict and break it down. Why was he found not guilty, yet someone else, like Michael Draka, similar facts, found guilty? You'll see it all when we come back. It's a tragedy.
Verdict. We, the jury, finds as follows. The defendant is not guilty. So say we all, this 25th day of February, 2022, juror number 2, foreperson. In the courts of the 6th Judicial Circuit in and for Pasco County, Florida, State of Florida versus Curtis Jetson Reeves, case number 2014 CF 216 CF AXES, information 4, count 2, aggravated battery. Verdict. We, the jury, finds as follows. The defendant is not guilty. So say we all, this 25th day of February, 2022, juror number 2, foreperson.
Shocking moment for many folks, including myself. I mean, I was here on the air. We brought you that verdict on Friday here during closing arguments. Curtis Reeves set free by this jury. The jury listening to his self-defense arguments, listening to his testimony, believing it, and again, setting Curtis Reeves free. An absolute explosion of reaction on social media to this one. Let me just give you a little sample of what's out there and what people were saying. For instance, Lou T posting this. Why in the world is this verdict making me feel some kind of way? No justice for Chad. My heart is broken. Lisa, I can't believe Grumpy was found not guilty. Oh, wait, I can. He was old and, quote, feeble and an ex-cop. The jury just took pity on him. And then there was Cynthia, who I believe was more in the minority, but still a lot of folks posting out there. Yes, justice was served for Curtis Reeves. Maybe this will make people think to respect others and turn that darn phone off and put it away when in a movie theater. Yay for Curtis Reeves, good for him. The younger generation has no respect for the public. Wow, wow. Now, one of the reasons I am shocked because I covered the trial of the man on the left that you see right there. His name is Michael Draka. He claimed self-defense in a very similar case in Pinellas County, Florida, which is right next to Pasco County, Florida, where Curtis Reeves was tried. Bunch of similarities. Let's start here with the first similarity between these two. Each one of these two started the verbal confrontation that began the situation that resulted in the shooting death. Let's start first with Curtis Reeves. He was in a movie theater. We've got the surveillance video of it, and was questioning Chad Olson's use of a cell phone, starting that verbal confrontation between the two. Let's switch to Michael Draka outside the convenience store at the gas station. There he is, again, in surveillance video, starting a verbal confrontation because someone is in a handicapped spot that doesn't have the handicap credentials. So both situations were started by the defendants. Now, let's take a look at the physical confrontation. And in both cases, the shooting victims start the physical confrontation. Let's first go to the popcorn toss. That is taking it from a verbal confrontation to a physical confrontation. And that was Chad Olson who did that. Okay, he started it, the shooting victim. Now let's go to Michael Draka. The shooting victim in that case, Marquise McLaughlin, walks out of the convenience store, sees someone yelling at his girlfriend, the mother of his children, and shoves Michael Draka. So in both cases, the physical confrontation is initiated by the shooting victim. Finally now, let's take a look one more time. Here we get to the actual shooting itself. And the shooting quickly follows the physical confrontation. We begin with Curtis Reeves, who once that popcorn is thrown at him, whips out that gun and shoots. And he says it's not a result of the popcorn, but was a result of the initial physical confrontation, which he claimed was the throwing of the cell phone. Okay? So Curtis Reeves says, I get hit by a cell phone, then some popcorn, and then I fire my weapon. Now let's take a look at what happens with Michael Draka as he shoots and kills Marquise McLaughlin. Again, the physical confrontation starts from Marquise, and then he pulls out his weapon and fires and shoots and kills Marquise McLaughlin. Bunch of similarities. Both shooting victims, fathers of young children. Both shooting victims shot in front of their significant other who testified at both trials. Let's bring back in the think tank still with us. Bernardo Villalona, Michael Bixon, Al Wunsch III. Two cases, both self-defense, okay? Both self-defense, both in the same area of Florida with two completely different results. Michael Draka behind bars for 20 years. Curtis Reeves this weekend walked his daughter down the aisle at her wedding. So, Michael Bixon, I'll begin with you. Make some sense of this to the folks at home. Why is one man serving 20 years and the other walking his daughter down the aisle?
Well, to be clear, I do think that there was a misapplication of the standard ground law in the Reeves case. So I need to lay that out there. I think it was the wrong decision. That being said, there was a distinct difference between the two cases in that in the Draka case, the victim retreated. And so you had both the judge and the jury eventually shoot down the self-defense argument. Whereas when the Reeves case, you didn't have any issue of retreat. That being said, I still think it was a complete overuse of force. I do not think that standard ground should have applied in this case, and it was a completely wrong decision by the jury.
When you say this case? Which one? We've got two.
Reeves.
Okay, gotcha. Al Wunsch, explain to the folks at home why Michael Draka is serving 20 years on the left of the screen and Curtis Reeves was at the wedding this weekend.
Vin, it's the end of the world as we know it. This doesn't make any sense at all. The situation with regards to Draka, the victim was backing up, but the victim was backing up because he took a gun out. And so I think, most normal people would have been kind of backing up at that point. But he took a tumble. He took a fall. he wasn't, hit with some popcorn. The situation with regards to Reeves, it's just absolutely mind-boggling to me. I don't know what the jurors, 6 jurors, first of all, I don't understand why that was the situation.
It's Florida,
But then
that's the
other
rules,
thing,
that's the rules. I think it was 6 for Draco also, in his case.
right, but what I'm saying is I never understood that with regards to a criminal case like that. There shouldn't be 6, there should be 12. There really needs to be 12 people sitting there deliberating. And that's what we have in Jersey.
But what you just told me is that Draco took a tumble, was actually shoved, but he was found guilty. And the guy who we think got hit, maybe the jury thinks he got hit by a cell phone, maybe got hit by some popcorn by a guy who's in another aisle of a movie theater, he's free.
Well, look, the bottom line is if I was Drake's attorney, I would do a change of venue to Kenosha, all right? And then he'd probably get off there. But the situation with
these 2 trials are in the same judicial district in Florida.
I understand
Al. There's
that.
no
But what I'm trying to
difference
tell
in
you,
the jury pool.
But this is the most bizarre case I have ever seen in my life. This doesn't make any sense whatsoever. The pushing of this guy, I don't think it was warranted to shoot him. I don't think at any point that
Right, and the jury agreed. He's doing 20 years. He's doing 20 years.
But the popcorn thing is even more bizarre to me. How they could have said that was self-defense.
Okay.
I mean, I made that joke about assault and battery, but I mean that's exactly what this was: assault and battery. And yet this man is getting off. And you said about the fact he was walking his daughter down the aisle and everything else, but he had been home the entire time, which is even more tragic.
Wouldn't have been allowed to go to the wedding without the not guilty verdict. Bernarda Villalona, can you make any sense for the folks at home? Because this is part of the outrage. People don't understand how these juries come to these verdicts. But these 2 cases are basically in the same judicial district down in Florida, different counties, Pasco and Pinellas, right next to each other.
So while there are some similarities, there are also some huge differences. Aside from completely different jurors that sat and listened to each case, you got to think when it came to Michael Draco, there was a point of reflection. There were a couple of seconds where Michael Draco had the time to actually reflect and see what was going on. Aside from that, remember with the Draco trial that prior bad act came in where he had done the same thing at a prior occasion, having to deal with a handicapped parking space. But also with Michael Draco, his statement came in, and in his videotape statement, he came off as being very macho, very cocky, very starting. He wasn't a likable person. Like at no time did he show any kind of remorse. It was almost like he was proud of having shot this man. Also, aside from that, he did not testify at the trial. So there was no testimony. The jury did not hear from Michael Draco. When we look at Curtis Reeves, we're looking at a much older man, a man that's 70-something years old, and also was a cop who served his county, who served those same people that are on that jury pool. And aside from that, he came off as a much more sympathetic guy when he testified. Like people actually could see their grandfather or an older person when they were listening and looking at Curtis Reeves testify. So those are the huge differences. One testified, one didn't. Different defense attorneys. Curtis Reeves' defense attorneys were much, much stronger in the sense that they were very strong at going at the prosecution and breaking apart their case. So I don't think necessarily that the jury had any doubt in the sense of, oh my God, he definitely did not do it. He definitely did not intend to kill him. I think that they probably think maybe he did, but the prosecution didn't prove that beyond a reasonable doubt.
All right, folks, great analysis, great perspective. Still ahead. On the docket tonight in Columbus, Ohio, a doctor is accused of murdering his own patients with fentanyl. Why would he do it, and what is his defense?
He was given doses just 20 minutes earlier that would take down an elephant.
Plus, actor, singer, and entertainer Jussie Smollet looking for a new trial after being convicted for his hate crime hoax. He's facing up to 3 years in prison. Tonight's 13th juror question: how much time should Jussie Smollet do?
Ordinary cat litter stinks. It's dusty, heavy.
On the docket tonight, the story involving a doctor who's accused of killing his own patients. So, what do you do if you're a doctor accused of killing your own patients? You want to hire a super high-profile attorney. That's exactly what he did. Here's the story of Dr. William Husel and his attorney, Jose Baez.
Mount Carmel West Hospital was an unlikely crime scene.
The scene of multiple murders, according to prosecutors. The accused killer, William Husel, a physician so admired he was named Doctor of the Year in 2014 by the hospital and nominated again in 2018, the same year he allegedly murdered 10 of his 14 victims.
They went to the hospital for help. Several of them were not sick enough that they were destined to die during their hospitalization. They all had one thing in common. William Husel was the nighttime ICU physician who ordered lethal levels of drugs or a combination of drugs with their removal from a ventilator.
Dr. Husel is accused of killing his victims with massive doses of narcotics and other meds. 10 to 20 times the recommended dose of fentanyl and 3 to 5 times the doses of benzodiazepines. Husel is being prosecuted for killing 14 patients over a period of 3 years, beginning in 2015.
Dying is a terrible, terrible event.
Jose Baez is defending Husel. The attorney made a name for himself in 2011, winning an acquittal for Casey Anthony, accused of killing her 3-year-old daughter.
We, the jury, find the defendant not guilty, so say we all.
In 2017, Baez defended former NFL star Aaron Hernandez in his double murder trial. A jury found him not guilty, but Hernandez would stay locked up, convicted of first-degree murder in another death. Now, Baez is turning his skills to defend this accused serial killer.
This is not a murder case. William Husel was exercising compassion to his patients and tried to free them from pain and let their last moments on earth be ones of peace.
Jose Baez says Husel was treating his patients who were near death for their pain and suffering, and suggested the hospital was shifting the blame onto his client for their own incompetence in tracking their meds.
You're going to hear that Mount Carmel had a big problem, and that was that there was a glitch in their system. And there's a huge problem when controlled substances are not being controlled.
It is not about criminal behavior of anyone other than the accused, William Husel. Ultimately, our case is about the fact that William Husel caused the death of our 14 victims.
Can he do it again is the question. I mean, Jose Baez has pulled off the impossible. The case down in Florida involving the killing and murder of Kaylee Marie Anthony, that beautiful little girl. Aaron Hernandez, the NFL superstar, had already been convicted of murder. Can he do it again? Let's bring the think tank. Bernardo Villalona, Michael Bixon, and Albert Wunsch III with us. You know, Al, your thoughts. I mean, you talk about potentially evil clients. There was none more hated than the one he represented down in Florida. Now he's representing a doctor accused of murdering 14 patients. Can this case be won?
Well, you know, it's interesting because they had an expert on that was on for today, finished up testimony today, and they went on a cross-examination. And the cross-examination, I thought, was not phenomenal under the circumstances. They were attacking the expert for being a Catholic that is not a believer in euthanasia, and then talking about what kind of fees he was getting to be there and things along those lines. You know, the funny part is that, you know, in a criminal case, I don't think that really is relevant with regards to the amount of money the expert's getting, as opposed to a civil case where that is always a great thing to throw in front of the jury, that, you know, the testimony is being bought and things along those lines. But under these circumstances, you know, it doesn't really make sense. This is going to be a case, another one, Vin, you know, like that Court TV is going to love, because he's going to have to take the stand to talk about what was going on. And it's going to be another opportunity for him to get up there and say, listen, you know, it's a compassionate practice that I have. and that I'm taking a look at the situation and that this person didn't have the will to live or the ability to live or was in such pain that, this is why I went to medical school, to be able to alleviate people's pain.
Bernarda, he charmed that jury, which, by the way, you know where that jury came from that was down in Florida? It came from Pinellas County, right? Same area with the Curtis Reeves, but okay. That being said, can he charm a jury and have them believe that this doctor is some sort of a saint? 14 dead patients.
Vinny, he can charm the jury and possibly win if I were his co-counsel. In regards to this case, Vinny, there are a lot of issues though, and that he's playing with and that he can emphasize to the jury. Because the investigation here was very shoddy, especially how he explained in his opening statement that it began with the hospital. And this is the same doctor who was named Doctor of the Year on 2 different occasions. But aside from that, Vinny, autopsies were not done on all 14 of these people that died, which is a huge issue when you're trying to blame his acts as causing their death, making the causation a homicide here. So that's going to be a huge issue. But aside from that, anyone who's ever had someone in ICU, unfortunately, I spent over a year and a half visiting a loved one in ICU, knows how painful it is to see someone suffering and you going to the nurse every couple of minutes asking, can you please give them some kind of pain medicine? Call who you have to call because you're hurting seeing this person in pain. So if there's anyone on that jury that has witnessed that I think is going to go a long, long way, and it's going to work in favor of the defense.
Michael Bixon, I want you to take a listen to the state's medical expert talking about just how much medication was given. Let's listen.
Yeah, he was given doses just 20 minutes earlier that would take down an elephant, and they had not had the full effect because the drugs are still increasing in their effect on the body at that time. So the amount of impact of stopping breathing is growing inside his body at the time that he's then given a double dose even more.
Michael Bixon, I mean, I don't think you could chalk it up to an accident when you're talking about enough medicine to take down an elephant.
Sure. I mean, and I totally understand. It's a lot, right? I don't think that anyone is going to disagree with that. The question is, was it medically appropriate? And just because it's a lot doesn't mean that it wasn't. I absolutely think this case is going to end up being a battle of the experts. I mean, right now it's the prosecution's show, but when the defense gets their chance, I do think that they're going to roll out witness after witness after witness of these experts coming out and saying that, yes, this was absolutely medically appropriate. And I do think that he's got more than a fighting chance. I think he's got a great chance at walking on this case.
All right, we shall see. Baez has done it before. We'll see if he can do it again. When we come back, it's time to hear from you, the 13th juror. It's a case where there's already been a verdict. Jussie Smollet, looking for a new trial, by the way, filed some motion papers, but he's going to be sentenced. Asking you what you think. How much time should he do for his hate crime hoax conviction? We'll be right back.
From business mogul to murder victim.
There he is, actor, singer, entertainer, Jussie Smollet, also convicted of the hate crime hoax, has filed a motion to have those charges just dismissed. The basis that the defense didn't have time to question the jurors or did not have an opportunity to voir dire the potential jurors. They also said that he was deprived of his right to a public trial because it happened during COVID and all his fans weren't allowed to come inside the courtroom. Well, he said the public, but he probably means his fans. He's got fans. So I posted all this on social media today and asked you, he's facing up to 3 years, and that's the range right now, 3 years in prison. The minimum is probation, so a pretty big range. And if you're Jussie Smollet, there's a big difference, even in serving 6 months in jail. I mean, you're a big-time entertainer, actor, star, to be put behind bars. So I asked you what you think is an appropriate sentence. How much time should he serve? We begin with the 13th juror comment of the day coming from Kimmy. He should do a day for every dollar spent investigating this nonsense. Who does he think he is? Throw out his conviction? That's about as laughable as his tale was. Let's bring back in our think tank. Bernardo Villalona, what's an appropriate punishment for Jussie Smollet?
You know what? I'm going to have to put aside that he's Jussie Smollet. If we were talking about anyone in general, I will say that definitely there has to be a jail sentence. And the reason for the jail sentence, don't everyone scream at me, is because of deterrence. You want to deter this conduct from happening again. You cannot use the cops. Cops you're taking away resources from and then say that a hate crime was committed against you because you make other hate crime victims and victims in general, you make people doubt what they're saying. So I think for a deterrence factor, you have to sentence him to some form of jail in this case. However, who knows what's going to happen? Because remember, originally he was given some kind of program where he served some kind of like a probation and then his case would have been sealed and done with. That was a possibility pre-trial. Here, now that he went to trial and testified, I think that the judge is going to sentence him even higher because he testified and he was found to be not credible.
Not taking responsibility for his actions. Joyce, tonight, I don't think prison would do him any good. He needs to pay back what the investigation into this hoax cost the taxpayers and publicly apologize to all of us. And that is taking responsibility, the public apology. Do you think we'll ever see or hear that, Michael Bixon?
I doubt it. I seriously, after everything that's gone on in this trial, I don't think that he's going to be apologizing. I do think that it would be a fair point to make him pay back restitution, though, in terms of the sentence, to find out how much the whole investigation, the trial, everything like that cost, because he's definitely got the means. So I do think that restitution is a serious possibility in terms of a good punishment.
Here's another interesting comment. This one from Carrie. He should do the amount of time that someone that actually committed the hate crime would do. He essentially committed a hate crime against himself. Can't do the time, don't do the crime. Judge Wunsch, your thoughts?
Yes. Ben, I don't think that he's going to be doing any serious time. I think it would be a 364 as a condition of probation. He'll do 2 years probation after that. I mean, the bottom line is that he's made a complete fool out of himself. I think his acting career is over. That's going to be penalty enough. With regards to restitution, I don't even know if the state can do restitution to that extent. I think they could sue him civilly. Something could be done along those lines to get back the money.
He's got
for
some
that.
pockets, though. I mean,
well, of course he does.
He's not just an actor; he's a singer too, Al.
Well, and quite good. But he didn't sing well enough on the stand to get the jury to be sympathetic to him. So he was a little out of tune that day, Vin.
There you go. Final comment from Christine. He's facing 3 years. I'm guessing if he's found guilty, he serves very little or no time and is sent home on probation and maybe some community service. Should he serve that community service in MAGA country or in Illinois, Bernardo? Only kidding. Great job tonight, everyone. Bernardo Villalona, Michael Bixon, Al Wunsch. Great to have you aboard. We'll see you again really, really soon. When we come back, folks, we have